like a hop, skip, and a jump, we're back. They're here. Oh my goodness. Sarah, she never disappoints. Battered woman. And she wants to claim self-defense. Now, how is this going to work for Sawa? How is Sawa going to claim self-defense? He was upside down in the Samsonite. I think we need some new additions to the bingo cards. I'm going to have, since I'm not good at stuff like that, I'm going to see if our friend Kat can help me with that because she's tech savvy. She is tech savvy. Well, we did it already this morning. Let's do it again. Let's tell everyone, hola. All right, and please do not forget, we have merchandise. Yes, we do. We have the merchandise because a lot of people want to watch this trial, and I am one of them. We will be streaming the trial, and I've got a little secret for you. Woo, maybe I shouldn't let the cat out of the bag. Maybe I should. I don't know. Should I let the cat out of the bag or not? I'm going to go ahead and tell you because we're just friends here. Our girl True Crime Beat is taking off on Wednesday to be at the trial. Yes. So she already has her t-shirt. There it is. It says, "That's my name. Don't wear it out. I need it for tomorrow." Boone's Farm Barbie. We got the spigot. We got it. So if anybody would like to purchase low quality merchandise at regular prices, you know who to hit up, and that's your girl Brooks. Let's do a little recap of what old Sawa has been up to.
All right, cheers. I want you to sit back down because I don't want you to have one more sip of water, please.
Yes, go on. That first 29 residential audible 1303 Island Day Drive.
I'll do what I can to get you a cup because I don't want you to have to keep doing that.
Is the statement should have a proper to cancel the indication for the front door. Right to that 1325. The motor unit on the panel.
The cups are like right there.
44 motor unit.
Right here. Don't talk to the ex-husband right now. I won't. Can I have a cigarette, please? Ma'am, I can't take anything out of the house. It's on the back porch. Nope. All of it. It's secure, okay? I'll try my best to get you what you need, okay? Maybe one of these deputies has a pack from someone, sit down and I'll try and get you what you need, okay?
Just cut, please.
Okay. I don't want you on your feet.
I don't want you on your feet. I just need a cigarette. I need a Dr. Pepper. Can you just go over there and get it for me? She's like, no. Now, this went on for about 2.5 hours. Judge Kreenick has way more patience than I could ever have with this woman. It has gone on and on and on for, well, February would be 5 years. He's done with her. Wooten was done with her. 8 other attorneys. Now she found her golden goose. But you know what she wants, my friends? Professional makeup done and hair. Now let's look at Sarah's hair, okay? Let's please look at it. Look at that, okay? That is the Bob of Shame. That is the county haircut right there. She wants it professionally done. It looks like a dickhead. It totally does. That's exactly what it looks like. Now, I mean, all the motions and everything, I think we can figure that out ourselves. But what I really want to concentrate on is the self-defense she's claiming. She's been trying this battered woman syndrome. I'm obsessed with the hair and makeup. I'm not gonna lie. Hey, Mermaid, can you take the link and come up? I want to talk to you. I have a proposition for Mermaid. Mermaid is really good with hair and makeup. If I get Mermaid a ticket to Orlando, I think we can all do it. We can all do it. The judge said that Sarah can put her makeup on before sitting there at the table. Now, I already asked TCB to take one for the team. I said, just go to the drug warehouse, pick you up some Maybelline. I said, go paint the barn for us. I'll take one for the team. Maybe we can get Mermaid to do it. Everybody together. Mermaid, 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 mermaid. She's even got new lip stain too. All right, let's see what Sarah has to say. Boy, everybody looks tired. They all look tired of her shit. Well, our friend Susan's in a bad mood. She said not 1 cent for her unless she will look like the clown she is. Well, you don't seem to have a lot of faith in Mermaid because, I mean, I'm looking for Lee press-on nails, and I'm talking those eyelashes that look like spiders. I want my girl all glammed up.
What is it that's been marked as Defense Exhibit B? Any objection?
Same objection. It's irrelevant.
Is it the form as of now, or is it the form as of 2020 when the... Okay. Can I see it for a moment, please? Thank you. Any additional argument with regard to the state's relevance objection?
Same argument.
No, I'm sorry, Mr. J, I wasn't specific.
Wanda's coming out of the chute. She said, I don't think makeup and a fancy hairstyle is going to help Sarah. I don't think so. I don't think so. She says after this she wants to be a flight attendant. Okay. I don't think I would want to be on that plane with her. This is also the same woman that said she was going to be an astronaut. So let's go. I'm here for it all day.
Enough. Mr. Owens, to you. Any additional argument? All right. I'm going to sustain the relevancy objection for the same reasons the court articulated previously. And Mr. Owens, you had one additional exhibit as well?
This is a composite exhibit, judges the policy of the sheriff's department.
Do you know what page specifically those policies are on?
Page 14 of 22. I'm going to give you 2 more pages.
Is it beginning of paragraph 4, waiver of constitutional rights?
Yes.
Okay, I've read pages 14 and 15.
Well, he's a speed reader. He's like, okay, I've read 14 and 15. Now can we get on with this? This bitch didn't take a plea back in 2020. So she keeps stomping up my docket. I can't do it anymore.
All right, Judge, and then you go to 13 of 28.
13?
13, well, it's the next,
Oh, there's two different sets. It's a
Split up.
composite. My apologies.
it's split up.
Got it.
13 of 28 at the bottom, P.
Mhm.
And then it goes on to the next page, 14 of 28. Specifically 2A on 14.
Anything else?
No other argument, Judge,
Okay.
other than what we've talked about.
Anything further?
Same arguments.
Okay, all right. I'm going to overrule the objection as to relevance as to what was pre-marked as composite C. And that'll be received into evidence over objection as states 1. I'm sorry, defense is 1. Any further witnesses, evidence, or testimony, sir?
Judge, I'd like to call Sarah Boone.
Ms. Boone can approach the podium.
Woo! Let me collect myself, please. Woo! Let me collect myself. I'd like to call Sarah Boone. I'm ready. I've got chills. Anyone else? Anyone else? Don't think she's not going to take the stand when trial starts next week. Don't even think she's not going to worm her way up there. Everybody sing with me. I got chills, they're multiplying, and I'm losing control. I don't know the words, so I just start humming after a while.
She was previously sworn at the beginning.
Judge, I'll be here.
Yes, sir. Hang on, the deputy's got to move her. Ma'am, you've already been sworn. Counselor, you may proceed.
And would you please state your full name?
Sarah Boone.
Well, you're going to have to speak up or move the mic.
Sarah Boone.
Yes.
Where are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020? Was that the date of this interrogation that we're here for on this motion?
Yes.
All right. Let me take you back to the morning of finding George Torres in the suitcase. You called 911?
Yes.
Is it true that Detective or Deputy
Mermaid said, Brooks, I can't do anything with that hair. I'm sorry. Yeah, you can. It's called extensions. Okay. Hair glue. But listen to her. Sarah Boone. I'm Sarah Boone.
Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
What mental state did you have at that time?
very confused. It was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking us from my home. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation, and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge. Move to strike. This is outside the motion to suppress. They have not made any allegations that her statement was involuntary because of her mental state or state of intoxication.
Response?
Judge, we're talking about, I'm just getting some preliminary information.
But we're
Her interrogation is the next day.
the state has an obligation, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Okay, this is the
Are
day
you-
before the interrogation.
I understand that.
We're not talking about an intoxication.
But are you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or
Okay, she said she was hungover from the Walgreens wine. Well, no shit. We saw that. Nobody is going to suck out the spigot unless they're severely hungover. Look at this.
All right, cheers. I want you to sit back down because I don't want you to have one more sip of water. Yes, go.
That for single 29 residential audible 13023 Island Day Drive.
I'll do what I can to get you a cup because I don't want you to have to keep doing that.
Is the statement should have the proper to cancel the indication for the front door. Right to that 1325. The motor unit on the channel.
The cups are like right there.
Here, 44 in the motor unit.
Sit right here. Don't talk to the ex-husband right now. I won't. Can I have a cigarette, please? Ma'am, I can't take anything out of the house. It's on the back porch. Nope, all of it. It's secure, okay? I'll try my best to get you what you need, okay? Maybe one of these deputies has a pack from someone, sit down and I'll try and get you what you need, okay?
Just cut, please.
Okay. I don't want you on your feet.
I don't want you on your feet. Who would?
coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
All right, I'm going to sustain the state's objection.
Relating to the intoxication?
Yes. It wasn't raised in any of the three motions that have been filed.
Judge, I didn't ask her that. She volunteered
I
that.
understand it.
Okay.
Objection sustained and it's stricken.
Did you speak to the deputy about what had happened?
Yes,
Okay. And then were you asked to stay on scene?
by both, yes. By both detectives, yes.
Okay. How long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically, but it was not quickly.
Okay. Did the two detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
No foundation.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detectives told you as it relates to you getting in the car? Was the phone issue before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Hope Cell asked me was if I owned a phone.
They asked me if I owned a phone. Okay, so of course they're going to ask you that. They're going to take it. They're going to take it, dum-dum. Remember what they found? Something you didn't remember since you're finally admitting you were hungover, which, by the way, is not a crime. They asked if I had a phone. You answered everything poignantly and then some. Sarah, you did.
And what did you tell them?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Sustained.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Copsell.
How did you unlock it?
She handed it to me and I unlocked it.
How do you unlock your phone?
It was with a passcode.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
All right. Did you ever see the phone again?
I did not.
Okay. After that incident, was the next time you
Not uncommon to not get your phone back because there's evidence on it. Am I the only person on this planet that doesn't have a passcode on their phone? I mean, really. I'm not too awfully embarrassed of things that I say. I don't have a boyfriend or anything, so I just don't really ever worry about it. You're exactly right, Susan. Susan said, blackout drunk. That's exactly what happened. That's the reason she was shocked as shit through a goose when they showed her that video and said, this is what we found. She's like, it wasn't intentional. It wasn't intentional. It wasn't intentional. But now we're hearing self-defense. Self-defense would be somehow intentional.
you were spoken to by Detective Copsell was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes,
All right. Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No,
Did they ever indicate to you that you were a person of interest?
no,
Did they ever refer to the videos that you recorded on your phone from the night before? Were you ever questioned about those videos at the scene?
I was not.
All right, after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes,
Were you allowed to leave the scene at that point?
I was instructed by those to not.
Okay. And how long did you stay on the scene?
The entire time,
How long was that? How long did it take before the investigation was completed?
10 hours or more.
At some point, did they all leave?
Yes,
And at some point, did they tell you they were finished with the work there at the scene?
yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband? And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Copsell?
I did.
And whose phone did you use?
Former husband, Brian Boone.
You said your phone had been seized
Correct.
and you had
Former husband, Brian Boone. She kills me. Sorry, I had to sneeze. Former husband, Brian Boone. Okay, listen. I could be wrong. I've been wrong before. I'll be wrong again, but I'm telling you, when she called Brian, it's because she is so used to him doing things for her. Okay? I think that she honestly thought that he would care enough about her and so little about morals and the law that she really thought he was going to scoop up that suitcase and go throw it in the ocean, in my opinion.
Consented to that, you signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Coatesville told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Coatesville's private cell number?
She gave it to me before she left the scene.
And did you call her?
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything or if I just wanted to talk to her about something regarding the case for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Sustained.
Go ahead.
There's no pending question at this time.
Okay, you were concerned about the case and you wanted to call her?
Yes.
And did you talk to her?
Yes.
What did you say to her?
I told her in all honesty that I felt that she was trying to trick me.
Irrelevant.
Sustained.
Did you have a conversation about your phone?
Yes. I asked her.
Overruled. You may answer the question, ma'am.
Did they call for a yes or no? She said yes, and now I don't know if I can.
Did y'all have a discussion about your phone?
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant and asked me if I remembered about when I was being pregnant, and it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
Was there any discussion about you being interrogated at the sheriff's department?
No.
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
Yes.
And the sole reason for the change in plans from them bringing the phone to you was because Detective Coatesville was pregnant and not feeling well? So the next afternoon, did you drive to the sheriff's department?
I did.
Tell us, when you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car and walked through the front door and went to the window asking who I needed to see, and they, I guess, rang them upstairs and...
Well, I just looked it up. Baby Kisses says, why do they have a preliminary if they're just going to have a trial anyways? Because what I read, I became a Google lawyer today. If what the judge hears in preliminary, he says, look, this isn't going to work in the trial. When we have all these jurors, then we're not going to court. Y'all have more work to do. But it seems like in this case, he said, oh yeah, you got enough.
Detective Lowen came downstairs, and I thought I was supposed to be picking my phone up over at a particular window, And he says, no, your phone is upstairs. So we would just like you to come upstairs, and that's where you can pick up your phone.
All right. And so did he escort you upstairs?
He did,
How did y'all get upstairs?
in an elevator.
And what was he wearing?
I believe he was wearing a red shirt along with his firearm and black pants
His firearm was on his waist?
the entire time, yes.
Okay. So y'all got off the elevator? Where did you go from there?
He brought me into a very small room, and they had me sit down, and then from there I had a list of things that I was going to ask them that I might need to do or that I could do.
Okay. So from the elevator, Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room? Okay. So directly off the elevator and walked into the interrogation room. And then we've got the video on that. Now, you and I have watched the video, correct? And you've seen the motion where I've referred to the questioning, where she asked you to sit down.
Yes,
You recall that happening.
yes,
Did that refresh your memory watching the video?
yes,
Do you recall her saying that she had received the autopsy?
yes,
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy?
yes,
This was prior to you being read your Miranda rights.
correct.
She also said, we're not done talking about the incident. You recall that?
Yes,
And then she said, we just have to do it.
yes.
How did that make you feel?
Sustained.
Were you trying to comply with the officer's demands?
Overruled.
In every way.
Were you trying to?
Okay, hold on. Were you trying to comply with the officer's demands? She says, in every way. Well, now, she couldn't 100% comply because she didn't remember what had gone on the night before. She also kept claiming that she just had one bottle of Walgreens wine. Well, there's a little bit more to it than that. A little bit more to it than that. I don't think she was as forthcoming as she says. Now, the question is, does she really remember this video or not? You be the judge.
Watch the video, correct? And you've seen the motion where I've referred to the questioning, where she asked you to sit down.
Yes,
You recall that happening.
yes,
Did that refresh your memory watching the video?
yes.
Do you recall her saying that she had received the autopsy?
Yes,
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy?
yes,
This was prior to you being read your Miranda rights.
correct.
She also said, we're not done talking about the incident. You recall that?
Yes,
And then she said, we just have to do it.
yes.
How did that make you feel?
Sustained.
Were you trying to comply with the officer's demands?
Overruled.
In every way.
Were you trying to cooperate?
In every way.
Were you polite with them?
Very.
And when she said that, we just have to do it, you said, just like we did yesterday.
Yes,
And then you said, normal protocol.
yes.
Is that what she had said the day before?
What do you mean?
Normal protocol.
Yes,
Had she said the same word? You said normal protocol to her.
I was reiterating to her what she had said to me the day before.
So she read the Miranda rights to you,
Except number 9.
except number 9. She read the rights, and then she said, do you understand what I've just read to you? And you agreed that you had. But you were not read having these rights in mind. Do you agree to speak to me now?
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights, and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
She did, correct.
So she never got the answer from you. Do you agree to speak to us now?
I was never asked that.
The way that she acted, the things that she said, the fact that they had your phone. Did you get the impression you were not getting your phone back if you didn't answer the questions?
Sustained.
She was in custody?
Yeah, it's been conceded by the state in their response that it was a custodial interrogation.
Okay, but she wasn't aware of it.
What do you mean she wasn't aware of it? I watched it. She wasn't aware that she was up Schitt's Creek without a paddle? Her attorney doesn't even know. She was in custody.
But she wasn't aware she was in custody.
What does her subjective perception matter?
Well, under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed small space. She was.
That all goes to
she was
whether or
being
not.
Let me think. She was being questioned by 2 lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her position is that she was coerced into answering the question.
What does that have to do with coercion? Those are all factors that under Ramirez as to whether or not it was custodial.
Well, I know some of the factors are whether or not the interrogation actually happens in a police station or not, or whether it happens outside a police station. So just that environment alone.
That goes to whether or not it was a custodial interrogation. That I'm struggling with the connection on that being not.
Hang on, I'm going to phone a friend because I need to know what's the difference between a custodial interrogation and a regular interrogation. I'm going to call my main squeeze real quick. There's only a few of us in here, so he shouldn't mind being put on the spot. I guarantee he sees this and he knows I'm live and he's just going to go, fuck. Hey, Rand.
Oh,
Hey, honey, are you watching this?
I'm listening to you.
Okay, so I have a question. What is the difference between interrogation and custodial interrogation? Because
Well-
Sarah's attorney is coming unglued saying that she didn't realize she was in any kind of trouble, I guess. Go ahead.
That's the angle he's going to work, of course. A custodial interrogation, another term for that is a preface ahead of that would be a custodial environment. So when you're in a custodial environment, you're not freely allowed to leave. You can't go to the bathroom and get up. You're there against your will. So you can't leave. You're in custody. You're in a custodial environment, hence the custodial interrogation. She's being questioned. She's being officially questioned by those detectives in regards to that crime. She is the subject of that investigation.
Okay. Like basically she's detained, but she just was the only person in the room that didn't realize it.
That's what she's claiming, and that's why that lawyer is using the last end of the Miranda, where he's saying that the female detective didn't ask if she understands, that she's going to be questioned. Is it okay for them to question her? I didn't hear that, so I can't rebut it or confirm it. So, but that's not an unusual tactic for an attorney to use in a criminal defense like that.
Well, and Susan said, fun fact, law enforcement can lie to you.
Yeah, but not when it comes to Miranda.
Okay.
Because when you're being Mirandized, you're actually losing your civil rights. Where
Okay.
you're under arrest. You're not free to go. You are now a suspect. You can't freely leave. So
Okay.
your civil rights are being revoked at that point.
All
So you
right.
can't-
Let's have a big round of applause for my husband. And she's also the primary suspect. Okay. Leilani Simon tried the same rigmarole.
Non-compliance with Miranda, coercion, or the third ground of voluntariness.
Well, and I think it goes subjectively to her and what she was feeling, if she had a free choice or not,
What's the subjectivity matter?
excuse me, based on
Subjectivity matter under the case law.
based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
I believe it's relevant.
Objection's overruled. I'm sorry, the objection's sustained. I apologize.
Did you understand you were not going to get your phone back until you answered their questions?
Sustained.
Did you have some questions for them at the end?
I did.
Did you feel like you had a choice in answering their questions?
Sustained.
Ma'am, that day, you came to the sheriff's department to get your phone?
Yes.
Did you know that you were going to be placed in custody?
I did not.
Did you know that you were going to be arrested?
I did not.
Did you know that you were going to be questioned?
I did not.
Were you trying to cooperate with law enforcement based on her statements that you have to talk to us?
Overruled.
Were you there answering the questions because she confirmed that this was normal protocol?
That was my understanding, yes.
That's all the questions I have.
Any cross-examination?
So that
Of course they have questions for her ass. Had she done a accidental factory reset, she wouldn't have gotten out of this. Had she taken the plea, she would only have a few more years. Hey, I'm not bitch mama bear. How are you? I'll tell you what, these baby voices in these cases make me so mad. You know, we heard it in the last show with Jen Soto. It's like they become 3 years old when they're talking to authority, like someone's going to get a heartstring pulled out.
That afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
You were impaired by alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
Okay. And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct? And you consumed no alcohol in your home that morning, correct? So does that affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon?
Ask one more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Copesel that afternoon?
Now or then?
Then,
Did alcohol affect my conversation with her?
there's a jury instruction that says a witness's memory and perception is pertinent. And I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect my answer?
Judge, I don't think she understands.
I don't.
Okay.
It's been asked 3 different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
I know that she said she didn't know
What are the legal grounds of your objection? All right, you may proceed.
All right. And you understand that you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct? Do you understand that the score sheet minimum is probably about 22 and a half years? Okay. And it is your desire to have these statements excluded from the jury's consideration, correct?
Judge, I would object.
Sustain the objection.
Your intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
Judge, I would object to that. I'm not understanding the question.
Mr. J.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Copesel's testimony, and the court, of course, in a motion to suppress has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witnessed today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon.
Response.
Judge, I agree with the impeachment about being under the influence. I agree with the impeachment about what she's facing. She may be biased because she's facing life in prison for 22 years or below. I agree with all that. We just got through the jail meeting with the state's expert who evaluates everything. I was present. The two prosecutors were present. It wasn't recorded. He can't be a witness. He's going to question her about what was said during that evaluation. He's putting himself in the position. I don't think that's a proper cross-examination about what she said.
Anything further? Mr. J.
I am not specifically asking her what she said that was different. And obviously, if I did and she testified differently, I would have to accept that answer. There's no way.
Does she look pissed to you guys? I haven't seen a face like this since Candace Wells did the 2-hour live about being constipated. She looks mighty upset.
For me to extrinsically impeach her with that due to the brevity of the time frame that we have all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
You gave statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020?
Yes.
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted?
Of course.
No other questions?
Any redirect examination? Okay. We can have Ms. Boone return back to counsel's table. While she's in the process of returning to counsel's table, anything else further from an evidence or testimony perspective from your side of the ledger?
No, sir.
Okay. Anything else from the state other than argument?
Just argument.
Okay. All right. Once Ms. Boone's seated, we could proceed with any argument. And as the court identified previously, I have reviewed all y'all's authorities that were provided. Mr. Owens, it's your motion, sir. You may proceed.
Judge, my understanding of the law regarding Miranda, first issue is, was the defendant in custody, was the suspect in custody? Was it a custodial interrogation? We have agreed or stipulated to that fact. We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two of that video. And I think under the totality of the circumstances, the court has to determine whether freely and voluntarily and knowingly given under the circumstances. Judge, law enforcement, after they get a valid waiver of rights, that I'm not going to be silent, that I'm going to answer questions, go ahead, ask me and I'll answer the questions. Once that happens, law enforcement is trying to get a confession. Law enforcement is trying to get admissions that they can later use at trial to impeach the defendant and convict him. The law allows law enforcement at that stage to use deception, to lie, to trick. We found the murder weapon. It's got your DNA on it. Your co-defendant has come in here and confessed and implicated you. All those techniques, when it's really deception, they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant, it can be utilized to obtain a confession or an admission of guilt. But prior to Miranda, you cannot deceive. Prior to Miranda, you cannot trick. That right is fundamental. You cannot be compelled to incriminate yourself. You cannot be forced to talk. It's got to be free will and a choice. And so you can't seduce or coerce someone into giving a statement. And the law is clear. When that happens, we've got to punish. law enforcement to correct that type of misuse behavior. It's illegal. So you got Detective Kopsel on the one hand, I got to read your rights. And you have a right to remain silent. But within a minute before, the detective is telling Sarah Boone, we have to do this. We have to talk to you. Now, that's confusing. That's deceptive. There's nowhere in policy that that should be allowed or is allowed. There's nowhere in the law that that should be allowed. It's actually illegal to tell a suspect, we have to talk to you. We just have to, before reading Miranda rights. That is an illegal.
Sad fact of the matter is, the Timu lawyer, that was great, retro, if he keeps attacking this Miranda, hey, Wiles old lady, haven't seen you in a while. If he keeps attacking the Miranda and they find one little thing, we've seen it happen in other cases, Sawa could get her way.
Statement. Sarah Boone did not have to talk to them about the autopsy. Sarah Boone did not have to talk further about what had happened. But that's the implication this detective gave Sarah Boone. It taints the Miranda that comes before it. Here's a law enforcement officer. I'm trying to cooperate. We've got to talk to you, but you have a right to remain silent.
But the statement of we have to read you the rights was made before we have to talk to you. So your argument transposes those two things chronologically.
Why are we even having it? I mean, why even have the confusion? I mean, we're sitting here Monday morning quarterbacking, but Sarah Boone was brought up there under false pretenses. A traumatic event, she lost her boyfriend. I'm coming to get my phone. I've been tricked into coming up here to get my phone. And I'm sitting here having to figure out what to do about whether to talk to these people or not. And she's talking about my rights, but then saying, we have to talk to you. We just need to do it. And then she reads the rights. Right there within a few seconds of each other. That's improper, it's illegal, it's coercive. It forces this not to be a valid waiver of her rights under that circumstance, coupled with the fact that she came down under false pretenses. Coupled with the fact she doesn't have the ninth question. If you think about it, okay, you got a right to remain silent, you got a right to a lawyer, those 3 or 4 questions, and then, do you understand what I've just read to you? I'm paraphrasing. But then Detective Kopsel goes right into questioning. Once Sarah says, yes, I understand, it's an acquiesce to authority. Okay, let me start asking her questions. The critical question is, having these rights in mind, do you agree to speak with us? That is the time of free choice. That is the time of decision for Sarah, to be given that opportunity. But the way I understand, Detective Kopsel had the autopsy. She had the blunt force trauma. Those were not questioned. Sarah Boone was not questioned about that. They didn't know about that until the medical examiner. So she had additional information. that she wanted from Sarah Boone. She had the 2 videos from Sarah Boone's phone. She had additional information from the phone that was inconsistent with the statement that Sarah had given the day before. So sure, any detective worth their salt would want a statement. She'd already said we had probable cause. We'd already made our mind up that we were going to arrest her. If she didn't come, they were going to go get her. If she came and said, I want to invoke my rights, she was going to be arrested. They wanted to get some type of admission, confession, statement that they could later use, which they're trying to do now. But under the circumstances, the totality of the circumstances about how she was induced to come down there, about telling them that she had to talk, Judge, it was coercive. We would ask that you suppress the evidence.
Any response?
Judge, the United States Supreme Court has said that confessions are good. They are good for society. It is good when guilty people are convicted. We stand by all the case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2-hour and 6-minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And under the case law, it was done perfectly fine. There is no requirement that that question number 9 get read. And as far as any credibility issues that are pertinent to the court's analysis, which the state would submit there is not, because we are conceding there was custody on February 25th. They are allowed to use subterfuge and deception to get somebody to come to the police station under the case law and authority cited. But if there is anything that is dependent upon the credibility of either the defendant's testimony or Detective Kopsel's testimony, the state would argue for the reasons of her being impaired by her own admission on the afternoon of February 24th, still from the night before, that her credibility is less than Detective Kopsel's. And of course, she has a bias and interest in the outcome of the case, whereas Detective Kopsel has no motivation to not tell the truth about whether she used deception to bring the defendant down to the police station, because that's perfectly acceptable. So we're asking you, for the reasons that we stated in our multiple responses to their multiple amended motions, to deny their motion to suppress. Thank you.
Any further argument, Mr. Owens?
No, Judge.
All right. Tomorrow is a court holiday. The court has had the opportunity to review all the case law. Court's going to prepare a written order, and you'll have it before the close of business tomorrow. Courthouse may be closed, but I'll be here working.
Judge, for the record, those 2 exhibits that I tried to introduce, they will be admitted
Correct.
into the record?
Yes, of course. They were pre-marked. Moving now to the defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial. State, what, if any, positions do you have with regard to the restraints?
Again, we've already decided that.
Oh, yes, I'm loving this. We have to hear the motion about cosmetics and civilian clothes. You cannot tell me that her attorney doesn't know somebody around Tallahassee that doesn't have some breeches and a blouse for Sarah to put on.
Issue. I don't know that there's been any new allegations alleged in the motions by Mr. Owens on behalf of the defendant, but the court has decided that already, and unless there was some sort of change in position or authority, then the court should maintain the law of the case.
Response.
Judge, I just want clarification.
The concern is if makeup is affixed and then she's taken back downstairs and then taken back to the Orange County Jail, they don't know if it's contraband, they don't know what's placed on her person. That's the concern.
There's just going to be some facial makeup.
I understand, but
I don't see.
DOC and sheriff's officer tell me they can't do it because of the concerns that were just outlined after she's returned to the Orange County Jail facility.
Okay. Okay.
All right. You'll get an order with regard to the restraints no later than tomorrow. Moving now to the state's request for protective order. I've reviewed that. I need to understand what you're looking at, Mr. Owens, with regard to these custodians and supervisors at the state attorney's office.
I did not realize that was going to be addressed today.
Yes, my JA had emailed all y'all, I think last week after it was filed, that said this would be added to the hearing for, I guess that was filed on Monday, forgive me. I had emailed y'all and said that it would be addressed today.
That was relating to me subpoenaing and listing I think it was
It's the third amended witness list lists certain people as witnesses: custodian of records, Orange County Office of State Attorney, domestic violence supervisor for the Office of the State Attorney, victim advocate supervisor for the Office of the State Attorney, and misdemeanor supervisor for the Office of the State Attorney. And the state is seeking a protective order on the grounds that it's work product or opinion product, and requiring prosecutors to disclose work product and impede criminal prosecutions is violative of Florida law.
But as you know, we have filed our notice of intent for battered spouse syndrome in conjunction with self-defense. And we have listed and plan to introduce the fact that George Torres had been arrested, I think, 3 or 4 times prior to this event. And I think on 3 of those cases, the case was dismissed against Mr. Torres. And it's going to come out that Sarah Boone had requested the charges be dismissed. And I believe it's going to come out probably through expert testimony that that's one of the conditions, or that's one of the things that they try to do, bond you out of bail and then get the charges dismissed as a battered spouse. That's a common theme. So ultimately, the jury is going to hear about that, but the jury needs to know it's the ultimate position. The victim doesn't have the final say. It's the ultimate position from the state attorney's office as to whether to prosecute a case or to drop a case. Yes, they are to consider what the victim wants, and they are to consider their request, but ultimately, the state attorney has to make that decision about whether a case is dismissed.
What are you going to be asking from these persons?
That.
How would that not be protected by work product?
Well,
As to whether or not it was a decision.
If it comes out that she went down there and requested the charges be dropped and they were dropped, then that gives the impression that she had the power and authority just to come down to the state attorney and ask the charges to be dropped, and they would. When in fact, the ultimate call is the state attorney's office. They don't have to drop cases even if a victim claims they do. So just that decision by the state attorney to drop it was their decision. They considered the victims, but it was their decision to drop it and their power and authority to do so, not the victim's authority.
Okay. Response?
Judge, that's opinion work product. That is absolutely protected. I don't understand why he believes that arrests and dismissals are relevant. What is relevant in a self-defense case is if the defendant is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from anybody, and it does not matter whether the defendant's aware of it. The notion that this sort of evidence would be admissible, much less through the vessel of sworn prosecutors, and they have now gone ahead and named people who aren't even involved with the cases. Matthew Storch, Christina Mills, and Aaron McCullough, our head victim advocate, have all now, I learned while we were at the jail this afternoon, been served with subpoenas by the defense, and we are moving to quash those. Prosecutors and victim advocates and other support staff cannot be forced to come in and say why they dropped a case. That is opinion work product. And if they want to get public records about these cases and try to get them moved into evidence, then they have to do public records requests or compel discovery from the state attorney's office, which I believe we all have. The state has just been dropped with her medical records that Investigator Lane got in 2021, even though they keep on saying in their amended discovery exhibits that don't even have this evidence. We got dropped last Friday, the Aspire records and the Advent Health records that have documentation that Billy Lane picked them up in 2021. So the defendants had these things that are getting dropped on the state for years, and we're just getting dropped on us this Friday. And now we are having to combat subpoenas and requests for documents. It is opinion work product. The people that they have listed didn't handle those cases or make those decisions, but that is the ultimate protection, is why we drop these cases. And it's up to the defendant if she wants to come in and say, yeah, I asked to get these cases dropped. I mean, that evidence is coming in anyways through her phone extraction. She is immediately working to bail the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone. So all that evidence is going to come in, but it cannot be coming in through opinion work product of the assistant state attorneys and our support staff.
Any further argument?
I didn't make the argument. I did not make the argument that the state attorney was going to be called to ask why they dropped it, as he just referred to, where they had to explain why the case was dismissed. No, the reason for that is just to explain that they have the ultimate power to dismiss, not the victim in a case. Not why we chose to drop 3 cases against George Torres, but they have the ultimate authority. The victim does not control the case, the state attorney does.
You have a written order on the motion, protective order for tomorrow, as by tomorrow as well.
Okay. What the hell? I mean, what the hell? You'll have an order by tomorrow. Is it just me, or is anyone super anxious about this makeup situation? Because this is not the end of it. Just because the judge says, no, it's contraband in the jail, they don't know what's what. They don't know. Paint the barn at the table before trial. Now, I don't see anything as of right now, what they're ordering, but, you know, I'm all in. All right, you guys, it's been a lot of fun having 2 shows today because you guys are the absolute best. That's Sarah. She is the gift that keeps giving. She really is. She won't stop. She's going to have a tantrum after tantrum after tantrum after tantrum. And don't think she's not going to show her ass in trial next week. If I was old boy, I'd go ahead and just skedaddle my ass down to the Goodwill and get her some clothes and say, there you go. Powder up your nose. We got things to do. There's some lipstick. That's all we can do for you. You look like a human. You don't look like you've been holed up for over 4 years. All right, you guys have a great rest of your day, and I'll see you back here tomorrow because we have 2 shows again tomorrow. You guys are the absolute best. Thank you for being here, being my friends, and, well, being the best chat and best community on these nasty YouTube streets.